Okay, so we're on the home straight now. Absolutely, this will be the last video in this series, and it will not surprise you to know that the standards that are expected of lawyers when it comes to dealing with the community, with third parties, are significant. And dealings or the consequences of failing to deal professionally can include disciplinary actions from time to time. The two kinds of issues that will come up in this kind of, or this section, continuing on, that extent to which undertakings might be given to a third party could be a contractual duty personally of the lawyer who gives the undertaking. I'm not going to go into that in any detail. Spent quite a bit of time in the previous video with undertakings. Secondly, the way that we speak to and deal with third parties, including the other side in deals where we're representing one person and we're talking to their opponent, whether it's in a civil matter or a transaction, or even dealing with a prosecutor in a criminal case, or if you are the prosecutor, acting the person against whom you are acting. So it is important to deal with all of those third parties professionally. So what are the key issues that come out? Making threats, referring possible commission of crimes to an authority, or potentially, and I've got it on there, reporting to the media. So ultimately, it's very clear. It is unethical to threaten the institution of criminal proceedings against a person in default if they haven't satisfied a civil liability to your client. It is arguable that there is no ethical objection to you indicating that if you are concerned about the possible commission of a crime, for example, if goods haven't been returned to your client, you'll refer that matter to appropriate authorities. But actually telling somebody that they've committed a crime will be definitely an ethical breach. It is also probably not necessarily inappropriate to threaten to refer non-payment of a debt to the media, for example, although frankly I think it's a pretty nasty technique, and it shouldn't be used to draw publicity for the purpose of unrelated to the redress that you are seeking, and it certainly shouldn't be undertaken as a method to get publicity for yourself or your own law firm. In what circumstances then can a lawyer owe duties to a third party in court? As it says on the slide, a solicitor doesn't owe a duty to every passerby who they meet on the street, but only to the client who employs them. Broadly speaking, the same general rule remains. A lawyer acting on his client or her client's behalf owes no duty of care in tort to people who are not their clients. A concern that underscores the extension of tortious liability to non-clients is the risk of liability to an indeterminate class of persons. So as with any action in tort, we've got to think about proximity. So proximity is a concept that tort law has used frequently to restrict the boundaries of liability, making it really unsurprising in this case that some of the case law relating to lawyers' tortious duties to third parties is couched in terms of proximity. So when do we have to think about whether liability could potentially extend to a third party in tort? Where the lawyer has assumed a responsibility to that third party, whether it's giving an undertaking or in some other way, where the lawyer gives an opposing client an assurance or an undertaking, when a lawyer fails to notify an executor of a will about its contents, or when a lawyer owes a duty to disappointed beneficiaries. So fairly limited, but really it goes to the, I think really a lawyer's duties in tort to persons who are not their clients, really the standard tort tests really apply. Proximity, reasonableness, and foreseeability being key among them. Next, A question often arises is, can a lawyer have contractual duties to third parties as a consequence of acting as an agent for their clients? So lawyers often end up acting as agents or quasi-agents for clients in various respects. And depending on the scope of the authority that the client has conferred on them under the retainer or under the form of appointment, they may end up entering into contracts on the behalf or behest of the client and on their behalf. So a prudent lawyer would always ensure that any transaction that they enter into of this kind will be entered into as agent for the principal, with a clear stipulation that the lawyer is not undertaking personal liability, that they are merely acting as the agent for the principal, their client. But whether due to a lack of clarity in the terms of the transaction or for some other reason, the lawyer can be construed as assuming personal liability, including jointly with the client, clearly duties in contract will be attached. The professional rules require that lawyers who instruct third parties on behalf of a client but are not intending to accept personal liability for payment of that third party's fees need to advise the third party in advance. And the same general principle applies in respect of things like counsel fees, although this must be seen against the backdrop of historical general law prohibitions against counsel suing for their fees. And now the uniform law and legal profession legislation in each of the states now envisage that an instructing solicitor and a barrister can enter into a costs agreement, and that's declared to be enforceable like any other contract, and that's lifted that historical prohibition on counsel enforcing a fee claim in contract. Just keep that in mind when you're reading Del Ponte in particular, because many of the older cases sit in the light of that prohibition that previously existed. So other than agency, what about contract? Well, actually, I'm going to continue talking about agency when I think about it. So what duties does a lawyer have to third parties in contract? The key issue that really arises is the question of whether there would be responsibility for a breach of warranty in relation to the authority that a person has or a lawyer has when they're acting as an agent of a client. So an agent who asserts authority to represent a principal, so a solicitor who asserts that they have the authority to represent their client, but in fact has no authority to do that, will be liable to the third party with whom that they are dealing for breach of warranty of authority when that party has suffered some kind of loss. The action is for a breach of promise, and the promise is essentially you have warranted that that you have the authority that you profess to have. So, like with any other collateral warranty, to establish a warranty of authority requires proof of a contract under which a promise was being made, either expressly or by implication, for which the promisee, in this case the solicitor, the third party has given some kind of consideration. So the doctrine of breach of warranty of authority raises the spectre of a lawyer being liable in contract to non-clients. And the issues mainly arisen in the context of lawyers who have lacked authority to act for a client at all. It's been judicially noted, that, and I quote here, a solicitor who enters an appearance warrants that they have authority from the client to enter that appearance. The doctrine of breach of warranty of authority raises this question mainly in the context of lawyers who lack authority for the client at all. So it really goes back to the retainer. And before you, as a lawyer, make a promise to any third party on behalf of your client, you need to be very sure that you have authority to make that promise under the terms of the contract that you have with your client. So, what about inequity? Duties of confidentiality can be owed to third parties, or can they? Lawyers owe a duty of confidentiality to their clients. That comes out of contract, and it comes from out of equity as well as the professional rules. We've been through this a number of times. But in contract and in equity, a lawyer can also owe an enforceable confidentiality obligation to somebody who is not their client. The equitable duty itself is independent of the contract, so it can be imposed on a lawyer who receives information that equity considers should be protected from disclosure. In any case, lawyers need to avoid assuming confidentiality obligations that clash with the duties that they have to their clients, that require them to use information that's received in the course of the retainer for the benefit of the client. So as you now know, and I'm hopefully very comfortable with, a lawyer-client relationship is presumed to give right to a fiduciary duty, set of fiduciary duties on the part of the lawyer. Even so, as fiduciary duties are superimposed upon a relationship in circumstances where a court considers that a party should be protected from another party's potential abusive position, it stands to reason that lawyers can owe fiduciary duties to people who are not their clients as well. So the danger is that fiduciary duties owed to a client can conflict with those that they owe to a non-client, which places the lawyer in a no-win situation because they can't fulfill both. Prudent lawyers are always going to take care not to put themselves in the position of inviting a non-client to place trust in them, because there's a special danger there that the non-client is another party to the matter of the transaction and is not legally represented. Lawyers owe a duty of confidentiality to their clients, and this comes out of the contract that they have with them, equity and professional rules as well. But in contract and in equity, a lawyer can also end up owing enforceable confidentiality obligations to non-clients. As the equitable duty is independent of contract, it can be imposed on a lawyer who receives information that equity considers should be protected from disclosure. So the lawyer, again, will really end up in a no-win situation. Lawyers need to avoid assuming confidentiality obligations that clash with their duties to the clients, because they have a duty to use information received in the course of a retainer for the benefit of their client and for no one else. So particularly in circumstances where confidential information might be shared that you might end up with a duty to, or when you're dealing particularly with non-represented parties, you need to be very careful about ending up with obligation to those duties. What other ways can you end up with legal duties to third parties? So under statute, under section 18(1) of the Australian Consumer Law, a lawyer or a firm, or any person really, but a lawyer or a firm can be liable to a non-client for breach of the prescription against misleading or deceptive conduct. So that's supported by a variety of remedial avenues found in Part 5.2 of the Australian Consumer Law. So the ACL, as we tend to call it, or the Consumer Law, extends liability for loss to any person involved in a contravention. So lawyers may not even be directly engaged in misleading or deceptive conduct to be technically liable for that conduct. So a person involved in a contravention could include a person who has aided, abetted, counselled or procured the contravention, or has been in any way directly or indirectly knowingly concerned in or a party to the contravention. So again, this will become quite important when we think about our duties to obey the law, but it is important to recognise that we could end up with duties to third parties because of the way that we support our clients if we are not careful. And lastly, we do have professional duties to unrepresented parties. So a lawyer representing a party in a matter needs to avoid giving legal advice to an unrepresented party and to take reasonable steps to ensure that the latter isn't under the impression that the lawyer is looking after them, acting for them. Beyond this, a lawyer needs to exhibit the same standard of conduct in dealings with unrepresented parties as they do in dealings that they have with other lawyers on a matter. Now, the case law in relation to this tends to relate to litigation, but we need to think about this in transaction law as well. lot of reading this week. I won't apologise for it. There's a lot to get through. I hope this series of relatively short 20-minute or so videos has been helpful to navigating all of that. I'm sure you'll have some really fun and interesting discussions in the tutorials, and I will see you next week or you'll see me next week when we talk about duties to the court. Cheers.